And I thank the state for their indulgence. This is unusual. We have unusual circumstances today.
Of course, Your Honor, and we are always happy to indulge the court.
Thank you. You may proceed.
May it please the court, Roland Coleman on behalf of the state, filling in lieu of Catherine Decker, who recently retired and is spending as much time as she possibly can with her grandchildren.
Good for her.
This court should affirm the judgments because the juvenile court properly exercised its discretion in finding probable cause that the defendant had committed the offense, and because the trial court properly denied suppression, or properly found that the defendant had voluntarily and knowingly waived his Miranda rights.
Mr. Coleman, did I read the state's brief correctly, that there's more to them just being present at the apartments 2 hours before the murder?
Yes, Your Honor,
They actually engaged at some level with the victim.
You're
Yes.
going to have to help me with that because I didn't get that from any of the briefs.
So my understanding of the record from the juvenile transfer hearing is that an individual testified that the defendant and co-defendant arrived at his house first, and that the co-defendant took a call that he seemed to be expecting, and that this defendant also seemed to be expecting that call and seemed to understand what it was about. After that phone call, they asked this individual to drive them over to the apartment complex where the murder actually took place. And on that drive over, at least the co-defendant was noticeably armed. Once they got there, another individual saw them get there and later saw I believe Judge Dyer said an interaction, or saw some sort of verbal commentary between the victims and the defendant and co-defendant. These young men were around a dumpster. One of them seemingly said something to the defendant, and I believe his co-defendant's name was Walton, excuse me. Said something to the defendant and Walton, and the defendant and Walton turned around, exchanged a few words, and Walton then displayed a firearm.
Respectfully, I'm going to need the audience to be quiet or hold any comments.
Okay, that's my understanding of what the testimony was, that almost immediately after the shooting, several individuals were able to identify the defendant.
I guess what I didn't get was actual proof. You said several individuals identified, and we're talking about the juvenile transfer hearing, right?
Yes, Your Honor, that's
Not
my
the
understanding
trial.
of the record.
So these people testified and identified the defendant as being there versus, I guess, being the shooter. I mean, because to me, there's a difference between being there at some point prior to the murder and...
What was their actions after that as well? So I believe one individual, Michael Williams, testified at the transfer hearing, and that immediately after the shooting, he looked out and he saw two young men running away from where the shooting took place, and he was able to identify them as the defendant and the co-defendant in this case.
Okay, so that being said, people run. And
Certainly.
when a shooting happens, people scatter.
So
what is that?
That is one more straw that is added to the camel's back. So you've got this testimony that they were expecting a call, and they specifically asked to go to this place, that they were seen there exchanging words and displaying weapons to the victims, that immediately after the shooting, at least one eyewitness testified that I saw them running away from that place, and then officers who arrived to investigate heard multiple people report. They were told...
Can you use that at the transfer hearing as proof that officers were told to talk to the defendant?
That is evidence that the juvenile court considered, and it was not objected to, Your Honor.
Okay.
Again, this is going to whether there is probable cause, not whether the defendant committed this beyond a reasonable doubt, but whether the evidence presented to the juvenile court was sufficient to meet this low bar of probable cause.
And were they saying that they needed to talk to the defendant, or that the defendant was the shooter, or that the defendant was involved? Because we have to read a lot into what basically led to the officer, what I read, arresting the defendant.
I understand, Your Honor, and my understanding of the record, and I'll guide this.
I know you're...
It's volume 12, pages 189 to 192, and then page 198, if this court wants to go and look at it itself. But my understanding is that people at the scene told officers that Several of them said the defendant and Mr. Walton were the shooters. Several said that Mr. Walton was the shooter and that the defendant was there with him. And then others told them that, hey, you need to go and talk to these two men. You need to catch these two men. And then the police dispatcher also received several anonymous calls specifically saying that the defendant and Mr. Walton were the shooters. And that's at volume 12, page 188. So there was sort of all of this proof, this leading up, this culmination leading up to the shooting, and then the defendant's actions immediately after the shooting where they're seen running and a little bit sweaty, and on top of that, the additional witnesses who reported to police either in person or via 911 to the police dispatch that the defendant was involved in this shooting. And again, this is a significantly low bar. Only has to establish that probable cause was established. And with sort of the totality of these circumstances, state submits that the trial court did not abuse its discretion in finding that that low bar had been met. And I think, Judge McMullen, you asked sort of what findings of fact, and I honestly don't remember exactly what the written order said, but the court based its oral finding, and this is at page 220 in the record, based upon the evidence presented by the state. So sort of, again, the culmination or the accumulation of all of these, this information, the court finds that there are reasonable grounds to believe that each juvenile committed the delinquent act of first-degree murder. And this court and our Supreme Court has held that reasonable grounds and probable cause are effectively the same finding. So, again, this was a pretty lengthy juvenile transfer hearing, and with a significant number of witnesses who, while no one directly testified that I saw the defendant pull out a gun and fire his weapon, establishes that he was involved in these murders. And again, if there are no further questions on that, we submit that the juvenile court properly exercised its discretion in binding this over. I did want to, you did ask Judge McMullen what happens if this court finds that it was improper, and that is that it does go back to the juvenile court. And while there are no state courts that have held this, there was a defendant who was on federal habeas that recently happened to. They found I think the Sixth Circuit.
Is that in your, I know Ms. Decker wrote the
I don't believe that was
Okay.
in the brief.
Okay, so I am interested in the site if you have it. What, the federal habeas case?
It was a federal, I can get it back to this. This is just based on sort of personal knowledge that has happened, but there was
Well, no need to come back. I'll look for that.
I believe it was the Sixth Circuit, and they found that the juvenile transfer hearing was improper and remanded it and had a subsequent juvenile transfer hearing.
Okay.
So that there are
Some-
property remedies for
okay.
this.
All right. So I know you're kind of winding down, but one of the troubling things for me, and I'm going to transition into the statement, the invocation of the death penalty in this case. Can you address that?
I can, with some caveats, I believe. First is that the defendant only challenges, with regards to these Callahan factors, only challenges the knowingness or voluntariness.
Okay, assume waiver's not with.
Assuming we're not talking about waiver,
waiver.
that is certainly one factor that weighs in his favor. But we're looking at, I believe, the Henderson factors at that point, which are similar to the Callahan factors, and a number of those weigh in favor of the state, or in favor of finding that this didn't sort of subsume his voluntariness of the statement. I think probably first and foremost what establishes that is that this was sort of at the onset of the statement, after he'd already waived his Miranda rights, and the defendant talked for at least another hour before really getting into, to be honest about what happened at the scene, at the shooting.
So I don't know if can be considered a threat, but throwing out the death penalty as a punishment for the defendant's actions in this case, that occurred at the top of this interrogation or in the middle, because I couldn't tell from the record because I hadn't watched the actual interview yet. And I just want to make sure it is in the record, correct? Because it wasn't on C-Track.
I believe it is on a video disc, Exhibit 30, or Exhibit 33, for identification, and that this court, I think it's a video that this court can watch. And my understanding is that around, and I don't know if these are timestamps or dates, or like, AM or PM, but around 2:39, Investigator Williams enters the room, reiterates the defendant's rights, and then makes this comment at around 2:41, so roughly 2 minutes later.
Okay.
And then the defendant, my understanding is, goes and continues talking and continues sort of making things up and hedging for roughly an hour.
So does it make a difference that it happened at the top of the statement, do you think? Because, I mean, I know the overarching issue is whether it had any bearing on overcoming his will and giving the statement. Does it make a difference that it came in at the top?
I don't think the timing of just when it came in makes much of a difference. I think the timing of when it came in versus when the defendant gave his confession is certainly relevant. And again, here we have almost an hour.
So if I understand your argument, then the fact that the threat of the death penalty was made and he just kept talking for over an hour before he finally confessed, you're saying that it's clear that that threat did not overbear his will and force him into confessing, whereas if it happened 2 minutes, 30 seconds, whatever, after they said it, and he said, fine, I confess, just don't send me,
I think that would be, if it were the statement is made and the defendant immediately says, well, I did it, I'm gonna be honest with you, total confession, that would bear much more in his favor than, again, taking an hour or more to not really be affected by it. And again, looking at some of the Callahan factors or the Huddleston factors, the defendant was treated respectfully. He clearly had the capacity to understand his rights and the consequences of both the waiver itself and giving the statement. He wasn't intoxicated or on any substances. He had no mental disease or disorder, gave no indication that he didn't understand his rights, and there was no promise of leniency.
So we're going to apply those factors because that's the law when we're looking at this issue. But it makes no difference if this police officer gave a completely incorrect statement of the law to the defendant.
It makes a difference, and when this court does the balancing, and when the trial court did the balancing, that certainly added more to the defendant's side and towards suppression. It's just that all the other factors and again, the totality of the circumstances were such that it is readily apparent the defendant's will wasn't overborne. He wasn't forced into this, into making this statement. And so the trial court properly determined that to the extent that we're looking at the voluntariness of the statement as a whole, which again, we would submit as waived, to that extent,
I understand state's waiver argument.
Thank you. I don't mean to beat a dead horse. Unless this court has any further questions, again, we ask that this court affirm the judgments.
Thank you.
Thank you.
And again, thank you for your accommodation.
Of course.
May it please the court? Based on the questions you just asked the state, you asked questions about was there any proof of whether or not there was any engagement between the two groups. On page 67 of the transcript of the juvenile court hearing, it's very clear from the testimony in there from Mr. Dance. It's a question, okay, at some point, did you see Justice Antonio by the trash cans? They walked past us. They walked past you. Did they say anything to you when they walked past you? He said something, but I didn't hear it. And again, referring to Mr. Walton. Okay, when you said he said something, but you didn't hear it, who is he? Justice. Justice? Did you respond to him when you didn't hear it? I said, what? Okay, and what did he do when you said that? He walked off. Question, he walked off. Did he show you anything? No, ma'am. Okay, he didn't pull anything up or out or show you. He raised up his shirt. We saw something silver. Ultimately, through impeachment of that statement, the witness said that he thought it was a silver handgun. That's all Justice Walton. So again, and forgive me, I call him Antonio Turner Adkins because, as you can tell from the title, the style of this, there's a lot of names here, and at trial, that's what we refer to him as. In page 121 of the transcript, Michael Williams clearly indicates that he was not comfortable with his identification at the time, said that it looked like them, was similar to them, and was not comfortable identifying either one of the defendants.
So again, I just want to make sure I'm clear on this. We're talking about the transfer hearing testimony?
Yes, testimony, transfer hearing.
And at the transfer hearing or the bind over, whatever you want to call it, it was a single juvenile. They didn't do it, like, the case wasn't severed or Or was it?
They were there together, so you have to be very careful when you read the transcript, make sure you know which one they're talking about. And when we talk about defendants, we have to be very careful to keep those two separate. The transfer hearing was done together, and I did the best I could to always make sure the
Okay.
witnesses were aware of that. I was trying to protect the record as best I could. I had other attorneys, and so sometimes that record gets a little muddled. But if you wade through it, you'll be able to separate out the testimony. Oh, and what others said was on page 189. And there's different places, but the one that specifically I would draw the court's attention to was 189, where it says, you just had concerned citizens, unknown people calling, saying, go talk to these two folks. The answer to the officer says, right, plus people on the scene. Question, who put them there like 2 hours before the shooting?
Only problem I have, Mr. Ferguson, the state just said this all came in and it wasn't objected to at all.
But it's, well, I mean, it's got to be admissible for a transfer hearing. I mean, for any kind of probable cause bind over, it's got to be admissible evidence. Again, unfortunately, I had other attorneys asking questions for their client who I don't object to because it's a different attorney. So that was the difficulty of having a combined transfer hearing.
Yeah, I don't know how it works, so you couldn't have done a individual juvenile transfer hearing?
I've never seen it done. I don't know if you can or can't. I know it was not done in this case, and the proof is much different for Justice than it is for Antonio.
That's what I'm hearing you say? Okay.
Yes.
And, okay.
But to your point, in the state's argument, it has to be admissible for a probable cause determination, but if no one objects to it.
Well, I think that's because the follow-up question was, were there people on the scene that were stressing that night saying that it was just, excuse me, the answer was, there were people in that scene that night saying that Justin Walton was the shooter. So again, it's exculpatory towards my client not being involved in the shooting. So.
But I mean, I'm just saying that the fact that there are people, as I understand it, at different times putting your client at the scene, involved with at least definitely the person who at least everyone saw with the gun, and no one objects to any of this testimony coming in.
And that testimony in no way implicates my client, nor was it, usually wasn't invoked by me. But the other problem is those people didn't testify. Any testimony at best is hearsay without any cross-examination.
Okay, that's what I'm getting at. You can call it hearsay all you want, but if no one objected to it, it came in.
Well, it's not, it's what the officer is using to establish probable cause to arrest, which he says he didn't have probable cause to arrest my client even after that. So it's coming in for a multitude of different reasons, and one of those is to establish what reason this officer had to arrest Antonio Turner Adkins. So there's no way to object to it because it goes to the basis of the officer's determination to continue the investigation towards Antonio Turner. And so it's completely admissible, but it's not relevant to the issue, which is, was there probable cause that Mr. Turner committed a crime? Well, the crime was obviously committed, but whether or not Mr. Antonio Turner had any criminal liability for that. So it comes in, it's admissible for other reasons, not for the purpose of probable cause.
Thank you, Mr.
Thank you.
Ferguson. And thank you for your accommodation as well. today.
Oh, yes, absolutely, anytime. It's been, I think, 6-7 years since I've been here, and I'm probably more nervous now than the first time I did it, so thank you for being nice to me.
Good to see you. We'll take the case under advisement. Thank you both.
Thank you.
Madam Clerk, call the next case.